What's good, YouTube? It's your boy, Blue Blood Sports TV, and I'm back at y'all with another one. So right here, we're going to listen to a defense attorney from Florida who breaks down the case of superstar boxer, former world champion, undefeated Gervonta Tank Davis, who has 28 wins, no losses, 30 wins, no losses, one draw, 28 wins by way of knockout. She's going to explain and break down his case. She's a defense attorney, high profile defense attorney in Florida. So she's going to break down the case. And I'm going to say this. She's breaking this case down. And if this young lady has lied, I hope that, and I'm not being callous to her situation, but I hope that Gervonta Tank Davis countersues, and I hope that Gervonta Tank Davis presses charges on her, because there needs to be examples made. You can't just be ruining people's reputations, brands, and names, and nothing comes of it, right? Again, I'm not saying he's innocent. I'm not saying any of those things, but I am saying if that is the case, she's not going to say that either. But I'm just saying if that is the case, because we see all too many cases and too many times that this is the case and there's no repercussions for it. You need to suffer the same fate. It need to be just as serious for the accuser as it is for the defense team. If you are lying and not telling the truth, there needs to be the same exact punishment that you're the person that you're accusing of was set to face. So in other words, what I'm saying is this will be able to prevent people from making false accusations against people, because they understand that if this proves not to be true, then you in return have to be punished to the same degree, or at least half of the degree that the defendant was facing. So if he's facing, let's say, for example, 7 years, and he's found innocent, and it's found that you were making up a story or you wasn't telling the truth, then you need to, then the accuser then at that point in time should be facing 3 to 5, at least half of it, right? If you are facing 10 years, then they need to be facing 5 at the very minimum. But let's listen to what she has to say, and she breaks this down.
Hey guys, Lisa Figueroa here, board-certified criminal defense attorney in Florida, here to talk to you today about Gervonta Davis. Now, if you didn't know, Gervonta Davis is a famous and very popular, very good professional boxer. But recently, the attention was drawn because he was arrested, picked up on a warrant that actually the warrant went out January 7th, and he was only arrested on January 28th or 29th, just a few days ago. Now, the charges he's facing are...
She's going to break down the charges that he's facing and everything that's in detail, right? So she's given a very detailed description of what he's facing and what we can expect of this case. So let's continue to listen.
Or attempted kidnapping, and he was only arrested on January 28th or 29th, just a few days ago. Now, the charges he's facing are 3 charges for now: kidnapping or attempted kidnapping, false imprisonment, both of which are felonies, and then a misdemeanor battery. Now,
so he's facing 2 felonies and a misdemeanor battery. Those are very, very serious offenses. And like I said before, it says, when you look it up, that the minimum this carries is 48 months, which is 4 years for, at the lowest, for kidnapping, alleged kidnapping, right? That carries a minimum sentence of 48 months. Right? These are serious charges, 2 felony charges. So again, he's a celebrity athlete, and if this holds not to be true, then she needs to be held accountable to the same degree that he was held accountable. So let's keep listening.
That's what the warrant was for. Anytime there's domestic violence allegations in Florida, we've talked about this before, it's going to be no bond initially until you go to jail, and at that point the judge will give a bond on the case most likely, and then set whatever pretrial release conditions, like no contact with the alleged victim and all of that. And apparently he did see the judge, and he was recently released on a bond. I reviewed the docket, and the state attorney hasn't filed formal charges yet. What is that?
So the state hasn't filed the state hasn't picked it up. They're going basically off of her claims, right? So the state hasn't yet picked up the case. But she's going to explain that even if this young lady doesn't want to continue to pursue the charges, then the state still might pick it up as long as they have the video proof and they deem that it's a possibility that she is in fear and she don't want to press charges because she is afraid that he can, get out and do something to her. She's going to explain this. So let's keep listening.
Mean when someone makes a claim that someone did something, an arrest warrant can go out, but until the prosecutor actually reviews that complaint to determine if it is sufficient, do they think they have enough to convince a jury beyond a reasonable doubt? Do they think that it's enough to go forward with these charges? Do they want to add charges? Do they want to go forward on maybe lesser charges? All of that gets reviewed, and then they file what's called an information. There has not yet been an information filed in this case. And
so what she's saying is, you see, the state hasn't. So it's civil. So she's doing it private, and the detective did his homework, and he saw the footage, and he believes that is enough footage that proves that he's guilty, right? So he's gonna so she's gonna break down if the state gonna pick it up. She's gonna break down every little detail. So let's keep listening.
And because of the nature of this type of charge, the docket, it's not public record. It is public record if you go.
So she's saying that you can't see the docket on the internet, but if you was to actually go in person and the person of importance, then you can actually go and you can see, you could get the documents. But right now, because it's such a high profile case and it's so serious, you can't get it online
in person, but it is not typically a scanned image that someone could download offline. Even with my credentials as an attorney, I'm unable to view the actual complaint. But there was a civil case filed related to the allegations.
So now she's breaking down that so she couldn't get the whole document, but she can break down from her viewpoint the civil case and what it's going to translate into the state case.
Here and an injunction. An injunction, some people call it a protective order, a stay away order. It's a civil mechanism that someone can file if you are afraid of physical violence, sometimes stalking or harassment. You can file, and it doesn't cost you anything. You don't have to have an attorney to file for an injunction. So if you are in an unsafe situation, any person that's an alleged victim of a crime, besides the criminal part, if any person who's an alleged victim and wants another individual who has either threatened them or they believe they are in imminent danger of some sort of physical harm, and maybe it hasn't even happened yet, but because of the history of those individuals, that person can go down to the clerk's office and file for an injunction, and they fill out an affidavit. Basically, there's a self-help usually in all clerk's office where they'll kind of guide you through. They can't give you legal advice, but they'll give you the form so that person, the victim, can actually tell their story on a piece of paper, and a judge will review it. The judge will review the petition to determine whether or not there is enough to give a temporary injunction, which means the parties can't have, the respondent, the person who is the threatening or abusive person, cannot have contact with the alleged victim until they go to court for an injunction hearing, at which time then the person that's accused of this injunction or this behavior, they have the opportunity to defend themselves.
So she's breaking down right now. She's breaking down, the order, the protective order against Gervonta Davis, right? So, she's just breaking down what the alleged victim is claiming, that she's afraid, of, his presence, and she wants an order of protection.
At that hearing. Now, this is civil. This is totally independent of the criminal case. And a lot of times, if I have cases like this, I'll have...
So he has a civil and a criminal case.
Both things are going on at the same time. You have the criminal case that's pending, and then the alleged victim will file for an injunction. Sometimes my client is wrongfully accused. You have a bitter ex-girlfriend or soon-to-be ex-wife that is mad and then makes these claims. He's arrested and then has to fight an injunction that's placed against him. So I've actually gone forward on an injunction hearing, and then we've gotten the injunction dismissed, or sometimes there's an injunction and there's no criminal case. Bottom line is that in the injunction, though, we're able to see in the petition what the allegations are, which I imagine is what is related to the criminal case. The allegations are that on...
So what she's saying is essentially what the alleged victim is claiming that took place in the civil case is pretty much what she's going to use, or the state is going to use against him in the criminal case, right? So the civil case is for her to be able to get compensated for her, being, alleged, abused, kidnapped, so on and so forth. The criminal is to punish him for said actions. So that's to get paid, and then the other one is to punish him for everything that she did.
September 20th.
Everything that he alleged did to her.
3rd of 2025, the petitioner states she was out at a restaurant and she received a text from the respondent, which would be Gervonta Davis. And
so she's saying that before this incident even happened, he had contact with her, and he reached out to her while she was at a restaurant, and he's going to allegedly threaten her.
He allegedly stated, I'm on my way to Playa. I don't know, Playa is a place.
Now, she don't understand the verbiage. She don't understand the slang that he's using while he's texting. She's saying that he's saying, I'm on my way to Playa. And she thinks that's, I'm talking about the lawyer. She thinks that he's saying the restaurant. He's telling her, I'm on my way, Playa. Right? So she figures that out as she keeps reading.
I'm on my way to Playa, and this is a quote, I'm
on my way to the Playa. No, I'm on my way, Playa. So he's saying to her, oh, you think you all that? Oh, all right, I'm on my way, Playa. You a player? All right, I'm on my way. So that's what he's saying to her. And then he says, I'm going to unalive you. Now, I'll skip the part where she, said that where she actually explained that he says in the text, I'm on my way, Playa, and I'm going to unalive you.
The respondent pulls up to the premises, grabbed the petitioner's neck, and choked her in the presence of several other people. The respondent's bodyguard intervened by grabbing the respondent's shoulder and told him to stop. The respondent, so this is Gervonta Davis's bodyguard that supposedly had to pull him off and stop him from doing something to her.
So the alleged victim is claiming that Gervonta Tank Davis's own bodyguard had to tell him to chill out. And more importantly, at the end of this, she's going to say, so there's all these witnesses that had better come forward and testify if this was the case. Because if not, again, she needs to face the same music that he's facing. Somebody needs to be punished for this, period. If he's innocent, then she needs to be punished. If he's guilty, then he needs to be punished. But she's alleging that his own bodyguard, and then later on she says that his bodyguard was the one that helped her get away. Watch.
After reading it in context, I guess I'm on my way. Play it to her.
Play it, yeah.
I'm on my way, Playa. I guess so, yes, not to the Playa. And then that's one incident. In these domestic injunctions, in order for a judge to grant it, for the most part, one incident is not enough. There's some case law that there has to be more than one. I don't know if that's still the case anymore, but it used to be that. And then there's another allegation in that petition for injunction that on October 27th, it says of 2055. I'm guessing that's a typo. The petitioner states that she was informed that the respondent was coming to her place of employment during her shift. However, the petitioner tried, and the petitioner is the alleged victim here, tried avoiding the respondent at all costs. Nonetheless, one of the petitioner's co-workers informed her that the respondent wanted to talk to her, but the petitioner refused, told the co-worker work was not the place for them to talk. Shortly thereafter, the respondent's bodyguard approached the petitioner and...
So now she's going to say that Gervonta Tank Davis's bodyguard approached her. So now she's saying that he went to one of her employees at her place of business told her he wanted to talk. She said, not now. Then he sent his bodyguard in to talk, and she says, not now. Now she's going to say that the place was closed and he was obviously hiding in VIP. And then this is where he pops up on her. So let's keep listening.
Reiterated the respondent's desire to talk to the petitioner again. So I wonder who the bodyguard is. Obviously, he's going to be a key witness. Around 4 a.m, while the petitioner was cleaning to leave her workstation to end the shift, the petitioner walked out of a VIP room.
See, so she's saying that she was cleaning up, shift was over, and he was still in the VIP.
And there was the respondent, and I had seen this in the news report about supposedly she works at a strip club and that he was there, and then that's where this all went down. Walks out of the VIP room. There was the respondent coming out of another VIP room. The respondent at that moment grabbed the petitioner by her hair and neck and stated to her in part, "Stop playing with me. I don't care. You're going to talk to me." The respondent then forcefully pushed the petitioner by stairwells to walk her outside of the business. One of the petitioner's co-workers that witnessed the respondent's actions, I mean, again, this is in public, so it's, if this happened.
So this is not public record because it's so serious. But she's saying that you have to be somebody of importance that you could walk into the building and you could get the actual case. So this is very, very serious, right?
There should be witnesses. Are these witnesses going to want to come forward? Did they speak to the police immediately? How available are they going to be? Is there another side of the story? We still don't know. I always say there's never an excuse for a man to put his hands on a woman. I would tell my sons. I have 2 sons, and I always.
So she's going into her personal life with the situation and her sons, and she tells men to keep their hands to themselves, so on and so forth.
Pushed her down the stairs, stated, "You're leaving with me." As the parties are walking towards the kitchen area, there were several employees. The respondent stated to her, "Don't cause a scene or I swear we're going to have a problem." The petitioner complied with his order, and then once they arrived at an isolated area, he again grabs her by the hair and begins slapping her on the back of the head at least 3 times, continues with his rampage, and they arrive at the garage. The respondent stated to the petitioner, "I don't care what you do, you're going to leave with me." And at that moment, a valet personnel witnessed the petitioner outside of the business, stated to her, "What are you doing outside?" And the respondent then walked in front of the petitioner to speak with the valet man, and the respondent's bodyguard told the petitioner to run back inside. Approximately an hour later, the
respondent's bodyguard, so that's Tank Davis's bodyguard, told her to run back inside. Listen again.
Outside of the business, stated to her, "What are you doing outside?" Petitioner, "I don't care what you do, you're going to leave with me." And at that moment, a valet personnel witnessed the petitioner outside of the business, stated to her, "What are you doing outside?" And the respondent then walked in front of the petitioner to speak with the valet man, and the respondent's bodyguard told the petitioner to run back inside. Approximately an hour later, the respondent texted the petitioner and stated to her, "I'm on my way to your house." The petitioner ignored the text, and then I guess a couple days later, the petitioner went to Miami Gardens PD and filed a report.
So she's saying that she got afraid. You know what I'm saying? After she got away, he didn't text her, "I'm coming to your house." He didn't show up, but then, she went and filed these reports because she was afraid that he would pop back up on her. So for all the people that's asking, well, why didn't she do it right away? Why didn't she do this, X, Y, and Z? You hear it right there. Again, so that means his bodyguard is going to be called to the stand. The valet Parker is going to be called to the stand. The 2 cooks in the kitchen are witnesses. They're going to be called. And her co-worker that he initially went to is going to be called. So this is very, very serious, man. 2 felonies and battery, man. This is, so again, if she could prove all this, then my heart goes out to her. If she can't, then she needs to be punished as well. And all these people, now we know he's a celebrity athlete. He got money. You know what I'm saying? Are they going to want to come forward and testify on the stand? Who knows? But this is a serious case, man. But you can see this interview in its totality, man, on it's called the Florida defense team. She's a defense lawyer. in the state of Florida. She goes over a lot of high-profile cases, Sakari Richardson, Elisa Andrews, she goes on and on and on with so many different cases. But you can check it out there, man. Again, it's called the Florida Defense Team. But let me know what y'all think, man. Drop a comment in the comment section. Follow me on Instagram at Blue Blood Sports TV, all one word. I'm gone. Peace.